Hi everyone, welcome to our Elite IRA Advisor Group video alert. Jeff and I are here to tell you about breaking news from the United States Supreme Court on bankruptcy protection for inherited IRAs. They're not protected.
That's pretty much it. You know, Ed, I don't know about you, but to me the biggest surprise of this whole case was the way in which the decision was handed out. 9-0. I mean,
Unanimous.
Unbelievable. We had the Vegas odds at 50-50, and it came out 9-0. All the justices ruled that it was not protected in bankruptcy.
And there are reasons.
Absolutely. In
that
fact,
makes sense.
It does. And the reasons that they cite do make sense. They cited 3 key reasons why they differentiated these as not being retirement accounts. And as a reminder, we talked about this a little bit at our meeting, but that was at the heart of this issue, is are inherited IRAs retirement accounts? Because the bankruptcy code, the federal bankruptcy code that is, protects a retirement funds. So are they retirement funds? The Supreme Court said no, they're not retirement funds. They are someone else's retirement funds that, upon their death, transform. And the reasons they gave were, first, as a non-spouse beneficiary, you can't add money. Actually, any beneficiary can't add money to an inherited IRA. So that's one reason. The second was that holders of inherited IRAs are required to start distributions pretty much right away. So if you have a 5-year-old that inherits, they're taking distributions at 6. How is that possibly for their retirement? Now, the rules are slightly different for spousal beneficiaries, and I think if there was a spousal beneficiary, the ruling might be different. So I think this would be very narrow in terms of non-spouse beneficiaries. Finally here, the last reason they gave was that inherited IRAs can be withdrawn at any time completely tax and penalty free, whereas that's not the case with most traditional accounts. As you know, typically you have to be 59 and a half. Now, digging a little bit deeper into the case, the court said that allowing debtors, this is an exact quote from the court, allowing debtors to protect funds held in traditional and Roth IRAs comports with the purpose of helping to ensure that debtors will be able to meet their basic needs during their retirement years. In other words, that's why that exemption was put there. They want to make sure that people have enough money to live on during retirement. But they said the same thing doesn't apply to inherited IRAs. If they had this type of exemption, the beneficiary could take it all and, in their words, buy a, quote, vacation home or sports car immediately after the bankruptcy proceedings are complete. And one thing that was interesting here is the court said that the same limitations, the legal limitations on traditional IRAs and Roth IRAs ensure that debtors who hold such accounts, these are their own accounts now, but haven't yet reached retirement age, do not enjoy a cash windfall by virtue of the exemption, because debtors are required to wait until 59 and a half before they may withdraw the funds penalty-free. That's not necessarily the case with Roth IRAs. It seems the Supreme Court doesn't quite understand the rules with regards to Roth IRA distributions, but their point is well taken, that these clearly are different characteristics than someone's own retirement funds. So that's it. And essentially what they said was this doesn't amount to the fresh start spirit of the bankruptcy rules, but rather a free pass, and that can't be allowed. So
remember, this is on inherited IRAs only in bankruptcy.
That's right, and only under the federal law. There may be state laws in some cases that protect these accounts under state law, and in light of this decision, it's probably likely that many states in the foreseeable future will amend their state codes to protect inherited IRAs and other inherited retirement accounts from creditors or bankruptcy proceedings.
So the bottom line is inherited IRAs are not protected. The Supreme Court says are not protected in bankruptcy, a unanimous ruling. We'll see you next time.